Hello, everyone. Thanks for joining us today for the annual meeting webinar. My name is Cliff Davis. I'm a shareholder here at Roberts Markel Weinberg Butler Haley. My practice consists solely of homeowner association law, and I'm in my 23rd year of doing it. Today, we're going to talk about the annual meeting, and this is annual meeting for 209 associations. So will not have any information for condominium annual meetings. It's for non-condominium, so the typical single-family neighborhood, single-family residential neighborhood, and townhome associations that are not condominiums. So let's get started. Some of the things we're going to talk about today are solicitation of candidates, in-person annual meetings, virtual annual meetings, voting methods, know your timeline, which really is something that is kind of a running theme throughout this presentation. Your timeline for sending out the notice, sending out the solicitation of candidates, giving the solicitation, and that all kind of depends on what voting methods you may be using. But it's something that you have to plan for annual meetings and know your timeline so that you don't come up 20 days out from your annual meeting and realize that you haven't done some things you need to do. And then the last thing we'll talk about a little bit is about amending the bylaws to address some of these issues. So let's start with the solicitation of candidates. As most of you already know, that if you have an association that has more than 100 lots, the law, Texas Property Code, requires that you solicit candidates to run for the board. And you've got to do it by at least one of the following three ways listed on this slide, or you can do any combination of the three. And you have to give the owners at least 10 days to respond to the solicitation and submit their name as a candidate. First one is you can mail it to every owner, which most associations probably don't mail solicitation notices unless you're doing an in-person meeting with proxy voting. You might include that in your meeting notice. Another way is to post the solicitation in a conspicuous manner on common area. If you have a mailbox, a clubhouse, try to get the word out there that you're looking for candidates, and sending a solicitation notice by email to every owner who's registered their email address. And then the third way, which is probably the most common, is to post the solicitation notice on the association website or other association operated social media website, and send the solicitation to each owner who has registered their email address. Note on here that we talk about that if you're using an absentee ballot, you might want to think about, and we'll talk about this some more also, of having the owners who want to run for the board fill out a candidate information sheet. And that's something that they'll put down some personal information about themselves, why they should be on the board, and you'll send that with the absentee ballot. And again, you're going to want to know your timeline on when to start your solicitation, depending on the type of meeting and the voting methods used. Let's go to the next one, Kyle. Talk a little bit about in-person annual meetings. Traditionally, that's the way that meetings have always been conducted, in person, and I'm sure all of you have been to some where there's some contention between the owners, the board members, the managers. The annual meeting is the time when you typically will conduct your election or vote on other matters, which you may have a special assessment vote or changing your governing documents. But generally, the only thing that will be voted on by the members at an annual meeting will be the election of board members, the election that's conducted every year. So one thing you need to know when you're getting ready for your annual meeting is know who can run for the board. So you need to make sure you're familiar with your articles of incorporation, or what's now called the certificate of formation, and your bylaws, which may say that only members can run for the board. And members are typically someone who is a record owner of property, meaning their name is on the deed. So some associations are limited to members can only run for the board. If your articles or certificate doesn't speak to that, or your bylaws don't speak to it, anyone can run for the board, whether or not they're an owner of property. So know who can run for the board, review your documents to know who's qualified to run for the board. Let's go to the next one, Kyle. The annual meeting notice. Make sure you provide a timely annual meeting notice. Per the Texas Property Code, has to be sent at least 10 days and no more than 60 days prior to the annual meeting. Now, having said that, if you're going to use absentee ballots, there's a little different standard because the property code requires that you give people at least 20 days to cast their vote by absentee ballot. So if you're going to use absentee ballots, you need to be safe and make sure you send it at least 20, and we typically recommend at least 25 days before the annual meeting. And this notice provision per the property code supersedes any contrary requirement in the governing documents, in your dedicatory instruments, which is a kind of a general term, umbrella term for all of the governing documents of an association. And I want to let everybody know that while we're doing this, you can type in questions during the chat. Time permitting at the end, we're going to answer as many questions as we can. I have a feeling there's going to be a lot of questions, so get them in there, and we will try to answer as many as we can. So let's talk about voting methods. For the longest time, there were two voting methods: in-person voting and proxy, and voting through a proxy. The law has loosened up a little bit and now provides 4 types of voting that we're going to go into a little more detail on. And the property code says that the association is not required to provide an owner with more than one voting method. And then the next sentence in that provision says an owner must be allowed to vote by absentee ballot or proxy. Now, there's sometimes some dispute over exactly what this provision means. Some people believe that you have to let people vote by absentee ballot and proxy. But if you read the sentence before that states that you only have to provide an owner with one voting method, and you read those together, we believe that you only have to provide one voting method. And if you only provide one voting method, it has to be either absentee ballot or proxy voting. So again, know that there are 4 voting methods, and again, we're going to talk about those some later, but the association is only required to provide at least one voting method. We generally recommend to try to provide 1 or 2 to give people an option, and we're going to talk about those in the next slides coming up here. So the first thing we're going to talk about is the proxy, which has, again, been in use for a long time. A lot of associations still use them. And I'm sure that if you are a manager and you have been to an annual meeting and use proxies, you know that they can create a lot of confusion with owners. That's not something that most people deal with every day as a proxy. They're very confusing to owners. And quite frankly, sometimes they're confusing to managers, depending on the type of proxy that's used. And so it's really important to know exactly what is a proxy. And a proxy is written authorization to allow a third party to cast the owner's vote. So if I'm an owner and I can't make it to the meeting, I can give someone else the right to cast my vote. There's a couple different kinds of proxies. One is called a traditional proxy. Doesn't include any candidate names on it. What this does is, I'm an owner, I sign my right to vote over to John Doe. John Doe votes as he sees fit using my proxy. There's one called a directed proxy, and that typically, for an election purposes, would include the candidate names on it. And I, as an owner, would look at it, at my directed proxy, decide which candidates I like, mark their name, and then my proxy holder has to vote for those candidates. All proxies we recommend also include power of substitution language. And what that means is that, if your secretary has been assigned 50 proxies for the proxies that are returned to the association and assigned to the secretary of the association or whatever board member is going to vote those proxies, and then that board member determines that they can't make it to the meeting, if you've got power of substitution language, they can assign those proxies to another person to vote in their stead. So they can give that to another board member that will be able to attend the meeting, and that board member can vote those proxies. And same with owners too. If the person they assign a proxy to can't make it, that proxy holder can assign that to someone else and let that person vote that proxy. We also recommend that proxies include language saying that they are valid for any rescheduling, reconvening, or continuation of the annual meeting. So if your annual meeting can't go on for some reason, you don't have quorum, or there's some kind of catastrophe where you can't hold it the night that it's scheduled, your proxy will clearly say that it can be used whenever that meeting is reconvened or rescheduled or continued. I've had more than one argument with people who the proxy says this is good for the annual meeting held on April 26, 2023. For whatever reason, the meeting can't be held that night. And someone argues, well, you can't use that proxy because it specifically says the date and time it's good for. It can't be used at any other time. The easiest way to avoid that argument is to use this language in your proxy that talks about that it's good for any rescheduling, reconvening, or continuation of the annual meeting. An important thing to remember, and this is a common error we see all the time, is that a proxy is not a ballot. So if you're using a directed proxy that has candidate names on it, technically you shouldn't count that proxy as a ballot. The proxy holder should fill out a ballot in accordance with the instructions on the proxy. So votes are cast by ballots. They're not cast by proxies. So if you're using a directed proxy and someone comes in and they've got, for example, 5 directed proxies, and all of them are to be voted the same, you would take those proxies, staple them to a ballot, write 5 votes on it, and then the proxy holder would mark the candidates as directed by the proxies and sign the proxy holder's name on it. So something just to keep in mind, votes are cast by ballots. Proxies are not ballots. Proxies are an assignment of a right to vote to a third party. And if it's a traditional proxy, that proxy holder votes as they see fit. If it's a directed proxy, that proxy holder votes as directed. And it might not just be for an election. It can be on a bylaw amendment or whatever is being voted on. If it's a directed proxy, when you're checking those proxies in and when the proxy holder fills out a ballot, you need to make sure that they are voting as directed. And that's something you can control there at the sign-in table or when you check the ballots. Let's go to the next one, Kyle. In-person and proxy voting. Again, this is a traditional way to vote. If you're using in-person and proxy voting, ballots should be given to each owner or to each proxy holder when they sign in at the annual meeting. Unless you're using absentee ballots, you should never provide ballots before the annual meeting. If you're using in-person voting, the ballots are handed out to the people in person at the annual meeting. Got a tip here to control the sign-in. If I'm sure that many of you have been at an annual meeting, an election, and you lose control of things at the sign-in table because there's a lot of things going on there. There's people signing in, there's people asking questions, there's people walking up with proxies, and you're trying to keep all of that straight. And it can be very confusing. And if it's a lot of people, and if it's a contested election, and people are showing up with dozens of proxies, or in some cases hundreds of proxies, it can be very confusing. You've got to control your sign-in. So one of the ways to try to do that is people that submit their proxies to the board to vote. Before the annual meeting, get your sign-in book, your sign-in sheet, get all your proxies beside it, and go find each owner's name that has submitted a proxy and write the word proxy by it. And then the proxy holder will sign in that place. Keep in mind that the proxy holder must appear at the meeting to fill out and sign a ballot. So if somebody walks in and they've got 10 proxies that are assigned to John Doe, but they're not John Doe, those proxies cannot be used unless there's power of substitution language that I talked about, and those proxies have been reassigned to the person holding them. But just kind of the basic thing to remember here is the proxy holder has to appear at the meeting to fill out and sign a ballot. If an owner submits a proxy and then decides, I'm going to come to the meeting and vote in person anyway, my advice to managers and associations is for any proxy that's not counted, for whatever reason that is, write directly on the proxy, not counted, and the reason. Owner voted in person. Not counted, the person that signed the proxy is not the homeowner per the association's records. Just write that reason on there so that it's clear in the event of a recount of why that proxy was not counted. It's easier if the information is directly on that proxy. One of the things that I hope that a lot of people take away from today is to consider maybe moving away from proxies and away from in-person voting. I'm sure some of you have been to meetings, and I've been to more than one, where just counting the ballots, the in-person ballots, and dealing with the proxies can take an hour, can take 2 hours, takes a lot of time. You know, now that you can use these other forms of voting, there's ways to do these meetings to where at the annual meeting, all you're doing is announcing voting results. You're not conducting the election at the meeting. We'll talk about that too as we go on here. Absentee ballots, probably more efficient than in-person and proxy voting, and can be very efficient when used in conjunction with electronic voting. So I have a lot of associations now that have moved to absentee ballots, and then a number of those offer absentee ballot and electronic voting. If you're going to use an absentee ballot, when you solicit candidates, it's a good idea to send out a candidate information form or some document name, something like that. And the people that want to run for the board need to fill that out and send it back in. And that will have information on it about the candidate and why they think they can run for, why they think they'd be good to run for the board. And when you mail out your meeting notice and your absentee ballot, you mail out that candidate information form with it so that the owners, the voters, can read a little bit about that candidate. One thing to keep in mind is we see a lot of these type forms and they don't clarify that the only thing the candidate needs to submit to get their name on the ballot is their name. They don't have to fill out that other information. I've seen some candidate information forms that say, you know, the following answers to the following are required. That's not the case. You know, on the ones I do, I make clear that here's some questions you can answer. It's optional. I mean, most people are going to answer them because, you know, clearly, if an owner looks at a form and there's only the candidate's name, they're probably not going to be inclined to vote for that person without knowing anything about them. Keep in mind that per the property code, absentee ballots count toward quorum. They can help you get to your quorum. Absentee ballots must be signed by the owner. They cannot be signed by another party. You cannot assign your right to sign an absentee ballot to another party. That makes it, in effect, a proxy. One tip that we advise associations, and I've done a number of times, is amending the bylaws to make quorum for an election conducted by absentee ballots the number of votes received. So if you send out 200 ballots and you get 25 back, whoever gets the most votes wins. For a lot of associations, this has helped them ensure that an election is conducted every year. I'm sure a lot of you have had associations that can't make quorum for whatever reason and may not have made it for years. If we amend the bylaws, change the quorum requirement, conduct the meeting by absentee ballot, there will be an election every year. It will happen. Absentee ballots have to include some statutory language that we're going to talk about in just a second. And again, owners and candidates should not be allowed to gather absentee ballots, and we're going to talk about that in a couple of seconds. And I've also put on here the property code section that talks about an election that's not taken at a meeting. So if you're conducting your election by absentee ballot, it's not happening at the meeting. And this is the provision that says that you've got to give owners at least 20 days to submit their ballot. And if you're using absentee ballot, again, that's going to affect kind of your timeline of sending out solicitation, of sending out your meeting notice. I mentioned before that absentee ballots have to have some statutory language, and this is that language here. It can be a little confusing because, as I'm sure you all know, sometimes the law is in a little bit of conflict with itself. You'll note on here that the last sentence of this says, you may submit an absentee ballot and later choose to attend any meeting in person, in which case any in-person vote will prevail. Well, there was a provision earlier we talked about in the property code that says you only have to submit, you can only have to allow one form of voting. So if you're using absentee ballot, but you're not allowing in-person voting, I put a note on the ballot on the right there that says, please note that there will be no in-person voting at the annual meeting. Now, to be clear, this is something that lawyers can fight about. And the question is, which of the law prevails? Does this prevail or does the earlier provision that says only one voting method has to be offered prevail? And as of right now, we don't know the answer to that. But for now, we're advising associations, you can use absentee ballot voting only. If you do, you have to include this provision. And if you're not allowing in-person voting, then also include this other provision that makes it clear that there will be no in-person voting at the annual meeting. All right, vote tabulation. Earlier I mentioned that if you use absentee ballots, they have to be signed by the owner, and that owners can't gather ballots, or candidates can't gather absentee ballots and turn them in. And that's because the Texas Property Code says that only vote tabulators should view ballots. So if someone's out there gathering ballots, absentee ballots, then they are seeing the ballots, which is in violation of this section of the Texas Property Code. So when you have an absentee ballot, that's returned to the association, and really the only people that are going to see that are the management company employees and the vote tabulators. And we'll talk about vote tabulators here in a second too. Typically I suggest for vote tabulators, it should be at least one management company employee if you have a management company, and two owners, two members who have volunteered to count the votes. And typically what I tell the management company employee is, you don't necessarily have to be involved in the counting, but just be there in case there's a question, to help out with any issues that might arise, but let the owners count the votes, let the owners agree on who won the election. You need to explain the obligations to the owners of what the requirement is. And the primary requirement is, first, they be able to count. And second, that they must keep the votes of each owner confidential. And that's in the property code. And to be clear, there's nothing in there about a penalty if they don't, but by law, they're required to keep the votes of the owners confidential. Let's go to the next one, Kyle. So this is a form that we see from time to time, or some variation of it. And you see at the top, it says proxy/absentee ballot. And we've talked before about how confusing proxies are just in general. I think when an owner gets something like this, it probably really blows their mind. And this is a form that should not be used. This mixes voting concepts, mixes proxy voting with absentee ballot voting. If you're going to have proxy voting and absentee ballot voting, there should be two separate forms that address the issues related to each of those voting forms. And to be honest with you, I don't really ever see a reason why you should have proxy and absentee ballot, or ROXY as we have it here, absentee ballot voting. The absentee ballot voting cuts out the middleman. The proxy voting involves a middleman. The owner assigns their right to another person, and that person goes and casts the vote. If you use absentee ballot, you cut out that middleman. The owner themselves votes, returns the ballot themselves that they sign, and you cut out the whole issue and ordeal of dealing with proxies. I am sure you have all been at meetings where somebody walks in with proxies and there's charges that they're fraudulent, or there's charges that they lied to people to get those proxies. Again, my experience is that proxies can be problematic. They're very confusing to owners, and now the law lets you move away. But kind of the bottom line on this slide is to move away from any form that mixes voting methods. There's no reason for it, and it's very confusing to the owners. Electronic voting. The law now allows for electronic voting. May lead to more owner participation in voting. I've used it in some fairly large subdivisions, and in some cases they've doubled or even done better than that in increasing the number of votes that are cast. The owners can sit there in their home, get on their computer, cast their vote. We typically recommend that you use a third party to avoid any appearance of any conflict or self-dealing or self-interest. We know that there are some management companies out there that have, in effect, kind of electronic voting software. I generally, sometimes the owners don't trust the board. Sometimes they don't trust the management company, who they see as a tool of the board. Sometimes they just don't trust the management company. And the way to avoid any of that, any appearance of any impropriety, is to retain a third party. There's several of them out there who, the way that works is that the owners register with that third party. They cast their vote directly with that third party. That third party provides a report of owner names, who they voted for, the time they voted. They provide all kind of information. And again, this provides owners a second method of voting. We don't think you can use electronic voting by itself because of the provision of the property code that I talked about earlier, but it can be used in conjunction with any of the other forms of voting. And we found it to be a big help in getting a lot of owners to vote. And again, if you're going to use electronic voting, it's another situation where your candidates probably need to should have submitted a candidate information form that you send to the owners. The electronic voting services that I've seen can put that information on their website so that when owners go to cast their vote electronically, they can look at those candidate information forms in real time while they're voting. Let's go to the next one. The election results. The board needs to talk beforehand about how they're going to announce those results. So do you want to announce how many votes each candidate received, or merely announce the results? It seems to me that boards are 50-50 on this, in my experience with them. Owners are always complaining that boards and associations aren't transparent. To me, the best way to be transparent is to announce the name of each candidate and how many votes they received. When we have any kind of public election in this country, you know how many votes everyone got. I don't see why that should be any different for associations. Some boards don't want to do it because it may embarrass someone who didn't get that many votes. But if I'm an owner, I'd like to know more information than less information. But if it's something that you have a question on, it's consult with as a board member, consult with your manager, consult with your legal counsel, and determine how y'all want to handle that. After the election, all ballots, all proxies, if you're using them, all tally sheets, the sign-in sheet should all be placed in one or more envelopes and sealed in front of the vote tabulators. The tabulators should sign and print their name and contact information on the outside of those. I have a lot of associations that have the tabulators sign across the seal of the envelope so that you can tell if it's been broken in the event of a recount. The tally sheets that the vote tabulators use to count the votes should also be signed by the vote tabulators. And again, once it goes into these envelopes, it cannot be looked at by anyone. Board members can't have access to that. No one can have access unless there is a request for a recount. And there's a property code provision that outlines how to request a recount and the timeline. And we'll have a slide on that here in just a second, I think. Well, first let's talk about virtual annual meetings a little bit. So the virtual meeting, can you do it? Should you do it? What about your bylaws? What about notice? How do we vote? Is a virtual meeting really a meeting? We learned a lot in COVID about how to handle virtual meetings. I don't know, maybe just a handful of associations were using virtual board meetings. I don't know of any that were really using virtual annual meetings before COVID, but we learned a lot why that happened. They are legal. A virtual meeting is really a meeting. And let's talk about those a little bit. So, management and board needs to decide what platform you're going to use. There's various platforms out there, Zoom, Microsoft Teams. You've got to make sure, if you're going to do a virtual meeting, that someone understands the technology, whether it be the manager or a board member. You need to practice, you need to test your system, practice, and do it over and over again beforehand. The thing you don't want to do is to get on a virtual meeting and have to kind of let everyone see that you're figuring out how to work this thing during the meeting. So practice, test your system, and practice. Who will run the meeting? It may be a board member that hosts the technological part of the meeting. It may be a manager that does that while the board members run the meeting. You've got to make all those decisions beforehand. Like with any meeting, go over your agenda and procedures. Our firm offers to provide the technology for annual meetings. There's probably some other attorneys that do the same thing, and takes away at least the technological aspect of it. So you just these are all things to think about if you're going to have a virtual meeting: is how you're going to do it, what platform you're going to use, who's going to run the meeting, and how that's all going to work. So it's all about planning. What about notice to the owners for a virtual meeting? Same notice requirement, at least 10 and no more than 60 days prior. And if you're using absentee ballots, know your timeline. Know that you're going to have to give a little more notice on that to give people the chance to cast their vote by absentee ballot. And during COVID, and even now today, the associations that are still using virtual meetings for their annual meetings, we're using absentee ballots. We're making the voting deadline the day before the meeting. We solicit vote tabulators who are owners who come to the management company's office and count the votes, or some other agreed upon place. They count the votes either the day of the meeting or the day before the meeting. And when you go into the virtual meeting, you're not having a vote, you're just announcing election results. Let's go to the next one. Things we talked about, they're just like an in-person meeting. You just got to test your setup, know who's going to do what, how to remain in control. Are you going to let the owners talk? The owner's going to communicate using the chat function, homeowner forum. If you're using a virtual meeting, we typically include something in the meeting notice asking owners to pre-submit questions. And that way we can get a bunch of questions in line when the homeowner forum portion comes up, if you have one, and just read off those pre-submitted questions. A lot of the ones I do, owners submit questions, either pre-submit questions or else, and then they can type questions in live in the chat function that are then read and answered if we know the answer at that time. So calculating quorum. Again, if you're using absentee ballot voting, you can count those toward your quorum. If you've amended your bylaws, quorum really won't be an issue. And we can talk about a little bit more about amending the bylaws too. Question of how do you approve the meeting minutes from the previous annual meeting? A lot of times what we do in ours is we send a copy of those meeting minutes with the meeting notice, tell owners they should review them. If they have a change or something they want to make, suggest a change, they submit that to the board. The board determines if that change will be made or not. And then at the virtual meeting, the board approves the meeting minutes. But first, the owners are given that opportunity to make any changes. And, the annual meeting minutes are typically very short. They just state when it was called to order, the election was held, who won the election. So they're usually not controversial. There's some cases where they may be. And again, that's something you can talk to your attorney about on how to handle if you think you're going to have a controversy with the meeting minutes, and how to handle getting them approved at a virtual meeting. I've mentioned it a few times where you need to know your timeline. And so this slides kind of talk about the type of voting used and what your timeline should be. In-person and traditional proxy. If you're doing it the old way, the old-fashioned way, you can include your solicitation in your meeting notice when you mail that out. Keep in mind, you got to give owners 10 days to respond to that solicitation. So we generally recommend sending your meeting notice at least 15 days for the meeting to allow for that 10-day response time. You include your traditional proxy with the meeting notice. Again, the traditional proxy allows the proxy holder to vote as they see fit. At the meeting, you hand out ballots with the candidate names, because you'll know those a day or two before the meeting when the deadline for the solicitation runs. The proxy holder must appear at the meeting to cast a vote if someone brings a proxy. Make sure you staple your proxies to the ballot, and then you can solicit vote tabulators at the meeting. So if you're going to use in-person proxy voting, you should send your meeting notice with your solicitation at least 15 days before the annual meeting or election date, to make sure that you meet all your deadlines. It gets a little more involved if you're using in-person voting and a directed proxy. Remember that a directed proxy includes the candidate names. So before you can send out that directed proxy, you need to know those candidate names, meaning you have to solicit your candidates at least 10 days, give the owners at least 10 days to respond. So you've got to get that solicitation out there a little earlier. Again, same thing, hand out ballots with the candidate names at the meeting, staple ballots to proxies. If you're going to use a directed proxy, you should start your solicitation process. We recommend at least 30 days before the annual meeting date. That'll give you time for the solicitations to be returned, the candidates to submit their names, and to timely send out your annual meeting notice. On the next slide, it talks about a virtual meeting where you're going to use absentee ballot voting and maybe absentee ballot voting and electronic voting. This one involves a little more work on the front end and a lot more time on the front end. But again, this will make your meeting very quicker, a lot faster if all you're doing at the meeting is announcing election results and not conducting the election. So keep in mind that if you're going to use absentee ballots, you've got to solicit candidates first. You get them to submit a candidate information form that you're going to mail to the owners with information about that candidate. You've got to send your meeting notice with your absentee ballot, your candidate form, and then whatever other annual meeting information you want to include at least 25 days before the date the ballot is due. And again, the law says you've got to give 20 days, but we just recommend, do 25 days before the date the ballot is due, which may be the date before the annual meeting. The meeting notice can include a solicitation of vote tabulators. And the way that I do that is put the solicitation of vote tabulators in the meeting notice, tell them that they have to appear either at the association's clubhouse on the day of the meeting or at the management company office between certain times to count the votes. Remember that the absentee ballot must include instructions on how to return the ballot. That's required by law. On the absentee ballot itself, you have to instruct the owners, this is how you return this ballot. I also recommend that you include that information on the meeting notice too. If you're going to have electronic voting, your meeting notice should give detailed instructions on how to cast a vote electronically. And that's something that you can work with your electronic voting provider. They can give you information on the easiest way to instruct owners on how to use their system. Keep in mind that owners should not assign their right, and we don't think they can assign their right to sign an absentee ballot to another owner. Owners and candidates cannot gather ballots, again, because the only people that should see ballots are the vote tabulators. Announce the name of the vote tabulators at the meeting. So if you've had a couple of owners that have come to the management company office the day before, the day of, and counted votes, their name should be announced at the meeting. And again, that's all about transparency. To say these are the owners, they volunteered, they came to our office yesterday and counted the votes, and that's the results that we're going to announce. And then you just simply announce those results at the annual meeting. For those of you that have done this, it can change your life. It can turn a 3-hour annual meeting into a 1-hour annual meeting, if not shorter. If you're going to use absentee ballots or absentee ballots and electronic voting, you need to start your solicitation process at least 45 days before the meeting date. That'll give you enough time to solicit your candidates, prepare the documents that need to be prepared, the absentee ballot, the notice, give the owners the 20 days to cast their ballots. So these are just kind of some sample timelines. Of course, the earlier you do it, the more time you'll have and the less stress you'll be under when it comes time to get that annual meeting election material out there to the owners. Let's go to the next one, Kyle. The recount. I mentioned before that the only people that should see the ballots are the vote tabulators unless there is a recount. Texas Property Code Section 209.0057 dictates the recount process. Not later than the 15-day after the meeting or when the election results are announced is when someone has to submit in writing a request for a recount. If they do that, that triggers a requirement that a recount be held. And the statute talks about who can conduct the recount. And the statute talks about the cost of the recount. If you hire a former judge to conduct the recount, they're going to want to be paid to do that. And when you figure out what that cost is, you can require that the person requesting the recount pay that amount in advance before the recount's done. If the recount changes the election results, the association has to reimburse the person that requested the recount for the amount they paid. If the recount does not change the election results, then the person who requested the recount is out the money they had to pay for the recount. So just be aware that recounts are dictated by the Texas Property Code. Here's the section where you can find it. One thing I did want to mention is, I talked a lot about solicitation of candidates that is required for associations with over 100 lots. There are lots that are, associations that are less than 100 lots. When I write those bylaws, I typically just put in there that before the meeting, before the election or the annual meeting where the election is going to be held, the association will take reasonable steps to notify the owners of their ability to submit their name as a candidate. And, really, if you follow the process that's required for the over 100 lot associations, then you've done that. But you should be taking reasonable steps, even if you're less than 100, to give every owner the opportunity to put their name in the hat as a candidate. What's next, Kyle? I think it might be amend the bylaws. So like I said, the laws changed a lot to allow virtual meetings, to allow alternative forms of voting. One thing to consider is amending your bylaws to kind of address these things specifically. We've had some associations that have used some of these different practices, and attorneys have challenged it, saying, well, your bylaws say this and you're not following the bylaws. And then you respond, well, the law allows it. And they say, well, the law says unless otherwise provided in some places, unless otherwise provided in your declaration. It just leads to an unnecessary argument. If possible, we strongly recommend, for this and just for various other reasons, all bylaws should be updated. We see a lot of bylaws now that are the original bylaws that have things in there like, the association shall have a corporate seal. Well, nobody has a corporate seal. They'll say things like, you can suspend voting rights if an owner is delinquent on assessments or if they have a deed restriction violation. That's against the law. You can't have qualifications for owners to run for the board. You can't stop an owner from voting in a board election. So a lot of bylaws out there are in conflict with the law. A lot of bylaws talk about, there shall be a nominating committee to nominate candidates. Well, most associations that have that language in their bylaws, it's my experience that they don't follow it. They haven't been doing it for years. And really now it's not necessary, especially if you're over 100 lots and you have to solicit candidates. So really you need to think about amending your bylaws. And the question is always, well, what vote is required to amend the bylaws? And the answer is a good lawyer answer. It depends. And it depends on the amendment language in the bylaws. If it says that it requires a vote of the owner, there may be a way around that using a provision in the Texas Business Organizations Code. There's not a consensus between the attorneys in the industry if that overrides the provisions of the bylaws. But if you want to think about amending your bylaws, and you can kind of expressly address how it's going to work when you use absentee ballots, how it's going to work when you use electronic voting, changing your quorum to say, that if you use absentee ballots, the quorum is the votes you get returned. Things like that. If you want to do those things, then talk to your attorney about amending your bylaws and what it'll take to do that. And again, it not only will help you out in these, but it'll also get rid of other things in your bylaws that are just outdated and really not useful anymore. I think we are now at the question part, Kyle, and I know I've seen some questions popping through here. So I'm going to kind of go to the top and try to start answering. Let's see. Please address 2090594 access to ballots. I think we've addressed that during the presentation, that really the only people that should see ballots are vote tabulators and a person conducting a recount under the section of the property code that we just talked about. What section of the property code applies to associations with less than 100 owners? Well, all sections apply unless they specifically say they don't. And the solicitation is one, the solicitation provision is one where it's really only required for associations with more than 100 lots. Don't members vote to approve the prior year meeting minutes as well? Yes, I mean that typically annual meeting minutes of the members are approved by the members. This is something we do see a lot of boards, get wrong at the annual meeting. A board member will make the motion. Really, the motion to approve the meeting minutes, if you're at an in-person meeting, should come from the floor, should be seconded from the floor, and the vote should come from the floor. Now, in a virtual meeting, it's a little trickier to do that, and that's one of the things that when I am in bylaws, I put some specific language on how to amend virtual meeting minutes at a virtual meeting. And like I kind of mentioned, it involves putting in when you send out the meeting notice, telling the owners, here's the annual meeting minutes from last year. If you want to propose a change, make your proposal. The board will look at it, and then the board will determine if that's a valid request to change those. Is there any other business that members can bring for a vote at the meeting without being properly noticed? I think the answer to that question is no. In the bylaws that I write, it specifically says the only thing that's going to happen at the annual meeting is what's on the notice, to clarify that if it's not already clarified in your bylaws. And really, the annual meeting, the purpose of that, like I mentioned too, is primarily to conduct the election. Again, there may be times when there's something else that you're voting on, a bylaw amendment, a declaration amendment. But at the annual meeting, an owner can't stand up and say, I will make a motion that we change landscapers. That's not proper. That's board business that the board decides. So really, you want to control your annual meeting to what is in the notice to try to keep it under control. Do the timeline for absentee voting the same for electronic voting? If you use absentee ballot voting and electronic voting, and you set your deadline to return absentee ballots, say, at 5 p.m. on May 3rd, you should also tell your electronic voting provider that they need to cut off the electronic voting at 5 p.m. on May 3rd, which they can do with, the push of a button. So typically my recommendation is that both of those voting methods should end at the exact same time. Does the proxy holder have to vote in the same manner if it is a directed proxy? When the in-person proxy holder votes, do they vote with multiple sections? Let's take the first one. Does the proxy holder have to vote? So if you're if John Doe has assigned you a proxy, and when you go to cast that ballot, you have to vote exactly as directed on that ballot for John Doe's vote. If you're an owner and you also have a vote, you can vote however you want. But if it's a directed proxy vote and you're casting the ballot on behalf of the owner that signed a directed proxy, you have to vote how they directed you. That's why it's called a directed proxy. The other proxy is a traditional proxy, where there's no direction on how to vote. You can vote any way that you see fit. When the in-person proxy holder votes, do they vote with multiple sections? I'm not sure I understand that question. Let me think about that, try to figure it out. If voting is done by absentee ballot, assuming solicitation of candidates was completed properly, does that mean quorum and nominations from the floor at an in-person meeting are no longer needed? Or do you still need quorum in order to count the absentee ballots? So unless you've amended your bylaws to do what I talked about a little earlier, to say that the quorum for an absentee ballot election is the number of ballots returned, you still have to comply with the bylaws. So if you haven't amended, you still have to meet quorum to do that, which is why it is really a good idea to seriously investigate amending and updating your bylaws. We don't even try to, I don't try to fix bylaws anymore. If somebody tells me we want to amend our bylaws, I'm going to prepare an entire new document and not try to fix what they have. So let me look at that question again. Yeah, you do still need quorum. One of the things I put in when I'm in bylaws now is that if there are going to be nominations from the floor, they're not required, and that if there are going to be nominations, it will be in the meeting notice that there is going to be nominations from the floor. If you're using absentee ballots or even directed proxies, it's really difficult for someone to get nominated from the floor and win, because people have already submitted their proxies, their directed proxies. So those ballots are going to be cast a certain way. They can't be changed. If you're using absentee ballots and trying to do in-person voting with nominations from the floor, there's very likely little chance that that person nominated from the floor at the annual meeting is going to be able to win. I just don't see, I don't see any reason anymore for nominating committees for nominations from the floor. A lot of associations now just take the position, this is your chance when we send out the solicitation to run for the board. If you don't submit your name, you're not going to be able to run for the board. So the assigned proxy is not valid for election if done by secret ballot prior to the election. So secret ballots are somewhat problematic. Arguably, if you're going to use, there are some bylaws that say vote shall be by secret ballot. Well, for a little bit, they were against the law, secret ballots. And then the law was changed to say, well, you can have them, but you got to have some rules on how they're handled. Again, secret ballots really aren't necessary any longer because the only people that should see the ballots are the vote tabulators and whoever conducts the recount. And even before they changed the law, my thought was always it's kind of counterintuitive for Americans is that there shouldn't be secret ballots in association meetings, in association votes, because to me, that's just a place there where there can be mischief or distrust. But if you're going to use secret ballots, that's something you need to talk to your attorney about to make sure that you're complying with the requirements of the property code with regard to the secret ballots. Let's see. I see a lot of proxies that say all proxies left blank are automatically assigned to the current secretary of the board of directors. Is this okay? Yes, that's okay. We see proxies sometime that say if you don't fill a person in and that person is called the proxy holder, then the proxy holder becomes the board of directors. We recommend against that language. If it's going to be assigned to a board member, it should say a specific board member, the secretary, the president. It should not be any board member who is up for election. So if your secretary is up for election, then your default proxy holder should not be the secretary. It should be another officer on the board. Can a proxy have an option stating that the proxy may be used for quorum? Yes, that's fairly typical proxy language for either traditional proxies and directed proxies, that one option may be this proxy is to be used for quorum purposes only. What if you have to have 4 nominations? If you're going to do 4 nominations, if you have to have them, so if your documents are written such that it has to happen, again, if you're going to use absentee ballots or directed proxy voting, those people probably aren't going to win, but you have to go through with having them if it's required. And then if it's, you may want to consider doing it the old-fashioned way, in person and proxy voting, and have nominations from the floor. But again, we think that just the best advice is to move away from that, amend your bylaws if you have to, shorten your annual meeting minutes. The thing with proxies is that typically my experience is that when they're most in use is when you have an angry homeowner, or you've got a rogue owners who want to take control of the board, and they go out and they walk in with 300 proxies. And there's just no reason for that anymore. Let owners vote for themselves, and they can vote for themselves by using absentee ballots and electronic voting. Let's see, can you announce the number of votes for each candidate after the votes have been tabulated? I think you can. I think that's a board decision on how they want to handle announcing results. Again, my thought is always the more transparency, the better. We have to have a quorum to be able to conduct our meeting, and are usually unable to make our quorum without collecting proxy forms in advance of the meeting. And again, the answer to that is to amend your bylaws. So one of the provisions I have in my bylaws, if there's not a meeting to be, if there's not an election to be conducted at the annual meeting, the quorum is the number of people that are there if you're having an in-person meeting. So you conduct your election by absentee ballot outside of the meeting, and the bylaws say whoever gets the most votes wins. And then to hold the annual meeting to announce the results, the quorum is whoever shows up. If you can't get quorum at an annual meeting, can you still proceed with board elections via absentee ballot rather than just proceed with only half a board? In this case, half the board doesn't want either of the candidates running, so they are not proceeding. That's a question we'll probably need to get some more information on. I think that was a little too specific to try to unwind and answer. What are your thoughts when an owner records a virtual meeting through Zoom? Even if you have turned off recording, they can still have a dictation feature turned on for hearing impaired. I think that's just one of those things that you just can't avoid. I mean, somebody could put a cassette recorder there and record it without you knowing about it too. There's some things you just can't control. If you choose not to record the meetings and make them available later, an owner may do so. You just have to be ready to deal with that. If there's anything that falls out from that, be ready to deal with it. We've had instances where owners have recorded things without anyone knowing, and then they play things out of context, and you just got to be able to respond to those when and if that happens. If we are soliciting candidates with the call to serve, should we allow for write-in candidates on the directed proxy? Again, I think if you've got more than 100 lots and you're required to solicit candidates, that's someone's option to run for the board. If they want to run for the board, they need to respond, not somebody else writing in their name who they may or may not know about it. And to be honest, I just think that as a practical matter, write-in candidates probably don't have much chance of getting election. Again, though, you may have to change your bylaws to get here if your bylaws state that you have to allow for write-in candidates. See, can the meeting notice and proxy be provided electronically? We still recommend that if your bylaws say that the meeting notice, the annual meeting notice, be sent or mailed, that it has to be mailed, regular mail, through the U.S. Post Office. You don't. It's just not worth it to face the argument, well, my email changed, or I don't have an email, or you might have elderly people that don't do email. We still think the best advice is that for the annual meeting, that it actually be mailed to everyone. Is the 10-day for candidate responses required or best practice? It's required. The property code requires that when you send a solicitation, you have to give the owners at least 10 days. We recommend that if you're mailing it, really, we recommend that you give 13, especially if you're mailing it just to account for mail time. And again, it's all about cutting off an argument. You don't want somebody to argue, well, you mailed it and you made the solicitation 10 days from the date you mailed the deadline, 10 days from the date you mailed it, but I didn't get it till 4 days later and I didn't have time to respond. Why avoid having to deal with that? Just mail it a little earlier or give people more time than you're required to give. This is a question about the previous year's annual meeting minutes. Is it required to send those out with a meeting notice, or can we place them on chairs at the meeting? I think it's not required to send those out with a meeting notice. But like we talked about, if you're doing a virtual meeting, you can't put them on the chairs. So you should send them out with the meeting notice to try to get people's opinion on trying to approve those. If electronically voting, should the results be announced prior to the meeting or at the meeting? I typically advise associations, if you're using absentee ballot voting, which those should be tallied before the meeting, and electronic voting, which will be tallied before the meeting, that you announce the results at the meeting. I mean, that's the purpose of the annual meeting for most associations, is to either conduct the election or nowadays to announce the election results. How do you handle from the 4 nominations using absentee electronic ballots? I talked about this a little bit earlier. I would try to remove that requirement if it's in your bylaws and you're required to solicit candidates. It's just, you can still do it if you have to, but again, those people just literally probably have no chance of winning at all. On a directed proxy, if the proxy holder votes differently than what the directed proxy says, is the directed proxy valid? So the question really is, if the proxy holder votes differently than what the directed proxy state, is the ballot valid? Remember, proxy is not a ballot. I'd say no, the ballot's not valid. They were instructed to vote a certain way and they didn't vote a certain way. What if you have too many tabulator volunteers? How do you choose them? That's just, I think, a board decision. You decide how many you're going to have and you announce that beforehand. We need volunteers. We're going to have 2, we're going to have 3, and the first 3 chosen will be the vote tabulators. A lot of times you may have 2 kind of groups out there vying for control of the board, and they become very suspicious about the vote tabulators. And a lot of times who's in these groups. You know who's on opposite sides. In that case, I try to advise boards, look, pick somebody from each group. Obviously you can't pick a candidate, you can't pick anybody that's related to a candidate, but try to pick somebody that is in each opposing group, so that you can try to avoid an argument that you're trying to stack the vote tabulators with people that you think are going to count the votes your way or favor one group over the other. There's a question here about suspending a member's right to vote apply to condos and condominiums. You can still suspend voting rights for delinquent owners. How long should an association hold the sealed envelope of ballots and proxies after the annual meeting? There's a lot of debate about this question. So you recall that you've got 15 days to, someone has 15 days to conduct a recount. I would probably hold them for at least 30 days, but after that, really, no one should be able to ever see that. And I don't see any reason to hold it any longer than that. The same with association records. Sometimes we have associations that tell us, well, we've got a storage room and our records go back 20 years. Well, why in the world would you keep 20 years of records? The statute, the property code says how long you have to keep most records. I wouldn't keep anything a day after that. There might be a few exceptions, but if you've got 20 years worth of records and you get in a lawsuit and somebody says, I want to see 20 years worth of records, you're going to have to produce them all. And there's no reason to do that. Are write-in candidates allowed on absentee ballots? I mean, I guess you could allow that if that's what you choose to do. Can you give some names of electronic voting companies? I mean, the one that I'm the most familiar with is called Vote HOA Now. There are some other ones. If you have a management company, whoever's asking this question, I would contact them about the names of some other ones, or you can just Google, HOA vote electronically, and I'm sure it will turn up all of them. There's a question here about new legislation that we do have a webinars on new legislation, and I don't really want to speculate on something that is not law yet, but we'll have some webinars and keep your eye open for those on new legislation that question is probably more suited for. Write-in spaces on absentee ballots, we've talked about that. If you allow for absentee ballot voting, can you announce the winner before the meeting? I mean, I think you can. I just think it's not really good form. Have the meeting, have the owners gather, and then announce the results in front of everybody. Will there be a copy of this presentation sent to the participants? I will get with our IT person about that. The presentation will be available on our website, rmwbh.com. There's numerous webinars on there. There's numerous educational articles on there, rmwbh.com. If an owner brings in multiple directed proxies with different votes, does each directed proxy get a ballot? The answer to that question is yes. If they're, you can group together directed proxies that are voted the same, and again, you would write the number of total votes on the ballot, or if you want to, you can just staple a ballot to every one and have them fill out every ballot. It's just a little easier if they're going to be the same to keep those together, write the number of votes on the ballot, make sure the vote tabulators understand that ballot counts for the number of votes written on it. But if the directed proxies are voted differently, there should be a separate ballot for each of those. Does anyone use the declining quorum? Yes, that's something else we put in our bylaws. A declining quorum provision where if you can't get quorum, you can adjourn the meeting and then immediately reconvene the meeting and the quorum will go down. But if you've also amended the bylaws, like I've discussed about how to quorum for absentee ballots, you won't need to do that. But yes, we do write a declining quorum provision in our bylaws. Let's see. This question about if you don't have quorum, should you do an absentee ballot? Yeah, I mean, again, I think you can avoid these quorum issues and these issues that associations are having with holding an election by updating and amending your bylaws and conducting your vote by absentee ballot, electronic voting, and guarantee that an election happens every year. This is, you mentioned that eligible members are those property owners on the deed. How does an HOA find out who is on the deed? That's probably something you might have to talk to your attorney about or your manager. A lot of management companies have access to databases where they can access deeds, or they have a way to request copies of deeds. Kind of a good starter would be, if you're in Houston and Harris County, to look at HCAD or look at your county's CAD. They're not always 100% correct, but a lot of times they're correct when they list who the owners are, and they will typically list the owners on the deed. Let's see, a candidate running for office cannot bring in proxies. A candidate running for office can bring in proxies. What a candidate running for office cannot do is gather absentee ballots if you're using absentee ballot voting. Remember, the only person that can see a ballot should be the vote tabulators and management company staff as they collect those ballots. Does the signature on the proxy matter whether it is electronic or wet? I guess it depends on what the electronic signature looks like. That's something you probably want to discuss with your attorney so they can look at your documents and make a decision kind of based on exactly what you've got in front of you. My IT person tells me the presentation will be emailed out to all attendees within the next couple of days. After the announcement of the candidate winner, do the existing board titles change, or does the candidate fill in the open board seat? So most bylaws say that the board titles, I assume you mean the officers, that officers are elected at the first board meeting after the election. So, if the president was up for re-election and the president did not get reelected, there's not the person that beat him is not the new president. You would wait till the next board meeting, and then the board would elect officers unless your governing documents say otherwise. We have a board of 3 people, and we only have 2 that put their name on the ballot, 1 incumbent and 1 new. So we didn't talk about that. If you have an uncontested election, so you've got 3 open positions, you only get 2 names. There's no reason to send out a ballot. There's no reason to send out a proxy. You just can announce those people as being named, placed on the board at the annual meeting. That's an uncontested election, and you don't have to hold an election. So let's say you've got this after the election, you still have a vacant position. The property code says that the remaining board members can appoint to fill a vacant position. That has to be done in the open session of a properly noticed board meeting. Kyle, did we get through all of them?
Yes, sir. We're through all of them.
Wow. Okay. Well, thank everybody for coming. Hopefully this helps some. Like Kyle mentioned in the chat, everyone will be getting a copy of this presentation. And if you have any questions on it, you can give us a call and maybe we can help you out. Thank you for coming.